I welcome Dr. Sangni and Dr. Shoklingam on stage. I'm sure most of you here have already worked and know of Professor Shoklingam, but I would still request Dr. Sangni to give an introduction to him before he takes the stage.
So officially we are starting our conference now. It is a privilege and an honor to introduce Professor K. Shoklingam because he is considered as a father of victimology in India. He has served in Asian Body and the World Society of Victimology. So we are really grateful that he has accepted an invitation to deliver a keynote address in this conference. I will read out. In fact, when I asked in my office that give me something about him, so that person doesn't know him, and they got a one-pager from the website where the victimology, when they said Indian victimology, it started with his name. Professor Shoklingam was the founding head of the Department of Criminology, University of Madras in 1983. He served as a Vice Chancellor of MS University, Tirunelveli in Tamil Nadu for 3.5 years. In his career, he has been awarded the Max Planck Research Fellowship thrice by the Max Planck Institute International and Foreign and Penal Law, Germany. The Distinguished International Scholar of the American Society of Criminology and the Tamil Nadu Scientist 96, and the University Grant Commission of Indian Hari Om Ashram National Award in 2003. He was the founding secretary of Indian Society of Criminology for 7 years and the founding president of Indian Society of Victimology for almost 15 years. He has been a life member of World Society of Victimology since 1985, and he served as a vice president of World Society of Victimology and also served in various other committees. And he is also a consultant to the United Nations Center for International Crime Prevention and is chairman of Thiruvallur Criminology Research Foundation, Chennai. He sits as a board member of the Institute of Victimology, established under the National Center for Victims of Crime, Sri Lanka, and has widely traveled and lectured at many universities in several countries, including the ICPC, Canada, and UNAFEI, Japan. In September 2005, he joined as a professor at Tokiwa University and established the University Graduate Victimology Center over there. After that, he also served as a emeritus professor in National Law University for 2 years. And now, right now, he is the chairman of Rajiv Gandhi National Institute of Youth Development in Chennai. So it is a great honor that he has come all the way from Kanyakumari to Delhi. And I would request him for 40 minutes, sir, a keynote address, because I want to give an opportunity to audience to ask questions. I know although the keynote addresses generally people need not to ask questions, but here we would like to have an opportunity if we have certain queries, I would like that for 20 minutes they can ask questions to you. Thank you very much. Please share your wisdom on journey of victimology in India.
my good friend, Professor Sanjeev Sani, Principal Director of the Jindal Institute of Behavioral Sciences, many of my good friends and colleagues, particularly from Australia, Sam and Dick from United States of America, and many other, my students who are professors in different universities who have assembled here, and the participants of this two-day international conference on victim assistance, victimology and victim assistance. Friends, ladies and gentlemen, if you had looked at the earlier program, you would have known that I am not the person to deliver the keynote address today. I had a little passive job. Professor Sani asked me to do as chair of a session in which my good friend from Germany, Professor Weitekamp, is supposed to deliver the keynote address. But just a couple of days before, Dr. Sani called me and said that, can I take the liberty of switching your role as a keynote speaker instead of chairing? I said, I never accept any such invitation unless I am given at least a month's time. He said, no, you don't need. So we had some arguments, and finally he said that you can talk on that will be most appropriate to talk on the journey of victimology in India, because I have been associated from the day one when victimology was grounded in this country. So on that condition, I accepted it, and he wanted me to speak for about 40 minutes. I agreed. Friends, historically for centuries, when a criminal event occurred, the society was always focusing on the offender who committed the crime, and whatever follow-up measures taken in relation to crime were on the person who encroached on the rights of a victim and not the victim who suffered at the hands of the offender. When penology was retributive in nature, the major objective of punishment to the offender was to inflict pain on the offender, making just deserts, so that the offender would undergo the suffering in the same manner as he caused to the victim. When years passed and decades moved, there was a change in approach towards the objectives of punishment, particularly after the advent of Caesar Beccaria, born in Italy in the year 1738. Beccaria wrote his most influential essay on crimes and punishments under the broad field of criminology in the year 1764, when he was 26 years old. Unlike few documents before it, Beccaria's essay on crimes and punishment proposed to protect the rights of criminals as well as the rights of their victims. In course of time, due to continuous criminological research, the scientific criminology believed that crime is a learned behavior and caused by adverse social and family conditions of the offender, and the treatment approach to the offender is the most effective way of handling crime and the criminal. During the period when criminology and penology dominated the scene of crime and punishment, victim was completely forgotten, and the personnel managing the criminal justice system got contented with the functions of investigation, prosecution, and punishment of the offender if the guilt of the accused was proved. The players of the criminal justice system did not think beyond that, and no wonder that victim was not in their agenda, and the sufferings of the victim before, during, and after the crime were completely ignored by the justice system. Now, a brief history of the emergence of victimology and rediscovery of the victim in the criminal justice system. In the modern era, only during the 1930s and early 1940s, victim was recognized as an entity during criminal trial by Benjamin Mendelssohn, a Romanian defense lawyer who examined the victim's role in a criminal transaction and utilized it to support his claim in the criminal court to mitigate the punishment of the offender. Later on, Mendelssohn was fascinated by the dynamics that happened between the offenders and the victims, and collected detailed information from the different stakeholders, such as victims, witnesses, and bystanders to a crime, and analyzed their responses and found a strong interpersonal relationship between victims and offenders. On the basis of his findings, Mendelssohn arrived at a six-step classification of victim from the perspective of legal consideration of victims' degree and extent of culpability. He was more interested in helping the offenders as a trial lawyer, as a defense lawyer. So to that extent, he utilized the role of the victim in the crime. It is Mendelssohn who coined the term victimology, which later on got him the recognition as pioneer in the field of victimology. Mendelssohn's significant contribution was the typology or classification of victims and his concept of general victimology, which according to him should include all types of victims who suffer pain or loss, regardless of the source of suffering. According to Mendelssohn, victims of natural disaster or victims of major illnesses, etc., also should come under the purview of victimology, as the common thread of victimization is suffering. After Mendelssohn, Hans von Hentig was one of the early pioneers who also made intensive study of victims and propounded the concept of criminal victim dyad, by which he meant that the victim was often a contributing cause to the criminal act. Hentig refuted the common belief that victim is a passive person and the offender is the only active person in the criminal-victim interaction. Hentig believed that a superficial examination of the outcome of a crime might present a distorted image of who the real victim is and who the real offender is. According to him, in each criminal transaction, a closer examination of the dynamics underlying the situation is required to understand the exact role of the victim in causing his own victimization. But it should be cautioned that Hentig was not naive to believe that in all crimes, the victims play an active role. Hentig also made his own typology of victims on the basis of the concept of vulnerability and the extent of vulnerability of the victims. One important fact of involvement of Hentig in the study of victims was more to unearth and understand the causation of crime than to help the victims. So victims, the interest of both Hentig and Mendelssohn were incidental and not primary. His treatise on interaction between perpetrator and the victim is the key to understand the mind of Hans von Hentig, that he was a criminologist interested in a deeper understanding of the etiology of crime. Subsequently, many scholars started studying the victims and their role in crime and also their position in the criminal justice system and the neglect of victims in the criminal justice system. Compensation to victims of crime is one of the earlier forms of victim assistance. During the late 1950s, you are aware, the British magistrate Margery Fry advocated the need for compensation to victims of crime, and the concept got acceptance first in New Zealand in 1963, which became the first country in the world to have a victim compensation law, followed by England in 1964, and then by US in California, in state of California in 1965. The major victimological development was witnessed during 1980s when President Ronald Reagan constituted the President's Task Force on Victims of Crime to examine the crime situation in US and the conditions of crime victims, with a mandate to commit to the committee to propose its recommendations to improve the conditions of victims. Now, report of the President's Task Force on Victims 1982. In the American history, for the first time, the woes and views of the victims unheeded for many years in the past were attended to by the President's Task Force, specially constituted by President Ronald Reagan. In the monumental report of the President's Task Force on Victims, the chairman of the committee, Louis Hyde Harrington, in his opening statement has mentioned, I quote, "Victims who do survive their attack and are brave enough to come forward turn to their government expecting it to do what a good government should, that is, protect the innocent. The American criminal justice system is absolutely dependent on the victims to cooperate. Without the cooperation of victims and witnesses in reporting and testifying about the crime, it is impossible in a free society to hold criminals accountable. When victims come forward to perform this vital service. However, they find little protection. They discover instead that they will be treated as appendages of a system appallingly out of balance. They learn that somewhere along the way, the system has lost track of the simple truth that it is supposed to be fair and to protect those who obey the law while punishing those who break it. Somewhere along the way, the system began to serve the lawyers and judges and the defendants, treating the victim with institutionalized disinterest. The neglect of crime victims is a national disgrace, according to Harrington. Unquote. The report has devoted separate chapters discussing the extent of crime situations in America. The police, the courts, corrections, organized crime, narcotics and drug abuse, offense of drunkenness, gun control, science and technology, and research as an instrument for reform. Voluminous data were collected through National Survey of Crime Victims, which revealed that Americans experienced far more crime than they actually report to the police. And there was much fear of crime among the citizens, which affected the basic quality of life of many Americans. The core conclusion of the commission, however, is that a significant reduction in crime can be achieved if the recommendations of this commission are implemented. The recommendations call for cooperative and concerted attack on crime by the federal government, the states, the counties, the cities, civic organizations, religious institutions, business groups, and individual citizens. They propose basic changes in the operations of police, schools, prosecutors, employment agencies, defenders, social workers, prisons, housing authorities, and probation and parole officers. So they recommended a multi-pronged attack to deal with the crime, with a more focus on victims. The President's Task Force on Victims of Crime report made valuable recommendations never found in the history for the improvement of the victims and enhancing their protection. This is the first step by a government-constituted committee to admit and recognize the appalling conditions of victims in the criminal justice system and to make far-reaching recommendations. The implementation of such recommendations took a long time, and gradually the victim found improvement in their treatment in many states in America. Now, taking up the recommendations of the task force report, the World Society of Victimology rose up to the occasion and started discussing the need for such an instrument the instrument for protection of victims and to maintain the rights of victims. On behalf of the World Society of Victimology, Irwin Waller, a professor of criminology from Ottawa, Canada, and Leroy Lombard prepared the draft instrument for protection and assistance to victims, which was discussed in the 5th International Symposium on Victimology held at Zagreb city in the former Yugoslavia in August 1985, and the instrument was fine-tuned. Now, what are the significant achievements through the World Society of Victimology's 5th International Symposium at Zagreb? The UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, 1985, which we are all talking much often about providing protection and assistance to victims of crime and abuse of power, owes its final fruition to a few dedicated individuals within and outside the United Nations. Ms. Irene Mellop, a civil servant working in the crime prevention section of the United Nations in New York, was essentially interested in a declaration on victims of abuse of power, while Professor Irwin Waller of the University of Ottawa was predominantly preoccupied with victims of crime. The final declaration, incorporating both these categories of victims, is the product of a lengthy process involving several rounds of discussions, lobbying, and numerous alterations, modifications, and compromises. Originally, there were two draft declarations. The first on victims of crime, drafted by Waller in 1983, and the second on victims of crime, drafted during the same year by Professor Leroy Lombard from the Wayne State University School of Law at the request of the Ms. Irene Mellop. At an ad hoc United Nations inter-regional meeting of experts held in Ottawa in July 1984, both these drafts were discussed by a working group. In consequence of the discussions, several changes were brought in and a single draft was prepared. This later draft came under further debate during the 7th United Nations Congress on the Prevention of Crime and the Treatment of Offenders held in Milano, in Italy, in 1985, finally resulting in the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, 1985. The 7th UN Congress and the Congress on the Prevention of Crime and Treatment of Offenders, 1985, and the inclusion of victims in the agenda for the first time in the UN Congress. The UN Congress on the Prevention of Crime and Treatment of Offenders are meetings of the high-level representatives of member countries of the UN who meet once in 5 years, wherein the policy exchanges and best practices on the prevention of crime and treatment of offenders are shared, discussed, and debated. It is viewed as a high-level intellectual forum to share the best practices followed among the nations to make the world a peaceful place to live with, less crime, and for creating standards for the prevention of crime and treatment of offenders. Many international instruments, right from the most revered document such as the Universal Declaration of Human Rights, and many other instruments protecting the rights of women, children, prisoners, etc., have been framed and adopted by the UN Congresses in the past, which were subsequently adopted by the General Assembly of the United Nations, leading the member countries considering and adopting or accepting those international instruments in toto or with modifications by the member countries. One such instrument was the UN Standard Minimum Rules for the Treatment of Prisoners, adopted by the UN Congress in 1955, followed by its adoption by the UN General Assembly. Interestingly, the United Nations had the rights of the offenders bar prisoners in the agenda of the UN Congress in 1955 itself and adopted the same, whereas victims found a place in the agenda of the 7th UN Congress in 1985, 30 years after the rights of the offenders, prisoners were given a legal recognition. However, it could be considered as a big victory for the victimologists, because for the first time in the history of the United Nations, the victims became an agenda item for discussion in the UN Congress on the Prevention of Crime and Treatment of Offenders. High-level governmental delegations from many countries, member countries, and selected individual experts by virtue of their expertise were invited for the UN Congress at Milan, Italy, held for 10 days from September 1 to 10, 1985. The Indian delegation, deputed by the Ministry of Home Affairs, Government of India, to the 7th UN Congress was led by Dr. S.M. Dias, an IPS officer, retired Inspector General of Police, and he served as honorary professor of criminology in the Department of Criminology of the University of Madras when I was there. I had the privilege of attending this 7th UN Congress at Milan as an individual expert, which gave me an opportunity to personally witness all the trials and tribulations during the discussions on the draft UN Declaration on victims. Though the item victims of crime found a place in the agenda of the 7th UN Congress, getting support from the official delegations from the member countries of the UN was a very tough task. And it was not a smooth going for the adoption of the Declaration of Victims, as powerful countries like United States and Russia had several reservations, particularly in accepting the part relating to victims of abuse of power, and were not ready to pass the declaration, which included both victims of crime and victims of abuse of power. I remember well that at this crucial time, the chairman of the Indian delegation, Dr. Dias, played a significant mediation role, bringing the dissenters over the discussion table during lunchtime and evening hours, and made them carefully review the sections relating to victims of abuse of power of the draft declaration on UN Declaration on Victims. After several rounds of discussions and modifications of certain clauses, he could persuade the members of the US and Russian delegation to have the Declaration of Victims passed unanimously by the Crime Congress. After the Declaration of Victims was passed by the UN Congress in September 1985 in Milan, the General Assembly of the United Nations, in its 96th plenary meeting, adopted the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power on 29 November 1985 as UN Resolution number 40/34. Now, coming to developments in India towards the victimological movement, now origin of the Indian Society of Victimology. When the master's degree program in criminology and forensic science was started in the year 1965 in Tamil Nadu. It was housed at the Madras Medical College originally, and the students used to visit various government departments such as police, prisons, forensic science, forensic medicine, and attend the lectures by the specialists, experts, practitioners in relevant fields related to the broad field of criminology. For the subjects like psychology of crime and delinquency and sociology of crime, we used to go to the Department of Psychology of the University of Madras and attend the classes of the very famous professor of psychology, Professor T. Shanmugam, and his colleagues. The first batch of students of criminology were about to complete their 2-year course in September 1967. At that time, Dr. Sivamurthy and I started the Criminology and Forensic Science Study Circle, a small academic forum for the students to gain leadership and also to understand the nuances of the principles of criminology. Professor T. Shanmugam, the then head of the Department of Psychology of the University of Madras, was the president, and Mr. N. Pichandi, the then director of Forensic Sciences, Government of Tamil Nadu, was the vice president of this small body which we established. We met the then Inspector General of Police of Tamil Nadu, Mr. F. V. Arul, and Mr. R. M. Mahadevan, then Director of Vigilance and Anti-Corruption, and requested both these reputed persons in the Indian Police Service to be the patrons of our study circle. Both of them admired our efforts and agreed to be patrons of our forum, which was a big boost for the young students. It was a great learning opportunity for us to organize and conduct meetings, special lectures, etc. under the auspices of this forum. Dr. Sivamurthy was the first secretary of the study circle. And after he left the department, I was elected as the secretary of the study circle. When I was a research scholar in the University of Madras, once Mr. Pichandi called me, the vice president of the forum, called me to his residence on a Sunday in the early months of 1970, and he told me that he had long discussions with Professor T. Shanmugam, the president of Criminology and Forensic Science Study Circle, about a new proposal of expanding the small forum of Criminology and Forensic Science Study Circle into a national level professional organization wherein all those interested in the scientific study of crime, exchange and dissemination of criminological knowledge for the benefit of society could be enlisted as members and organize annual conferences, seminars, special lectures and workshops, and also publish a journal where the new knowledge and scientific studies and their findings could be published. Our long deliberations on that Sunday were followed up, and a meeting was convened in the Department of Psychology, University of Madras, by Professor T. Shanmugam as the convener of the meeting to consider the proposal whether we should convert the study circle into a national organization for criminology. That historic meeting in the year 1970 unanimously resolved to convert the study circle into a national organization in the name and title of Indian Society of Criminology, established in 1970. Professor Shanmugam and Mr. Pichandi were unanimously elected as chairman and vice chairman of the society, respectively, with me as its founder secretary. And with a group of people, including the then Deputy Inspector General of Police, Mr. P. Paramaguru, in the Executive Committee of ISC. It was also decided to have Honorable Mr. Justice B.R. Krishnaiyer, a jurist, later a judge of the Supreme Court of India, to be the honorary president of the Indian Society of Criminology. The Indian Society of Criminology was formally inaugurated by the then Chief Minister of Tamil Nadu, Mr. M. Karunanidhi, on 18th November 1970, in which the two doyens, one, the legal luminary, Mr. S. Govind Swaminathan, then Advocate General of Tamil Nadu, and the other, Mr. R. M. Mahadevan, then Inspector General of Police of Tamil Nadu, addressed a large gathering of audience, which included several ministers of Tamil Nadu cabinet and many civil servants, police officers, university professors, and students in the historic Senate Hall of Madras University, hailing the establishment of Indian Society of Criminology and emphasizing the need for such a professional organization for the study, research, exchange, and dissemination of scientific ideas in criminology. The ISC focused on many issues relating to criminology, juvenile delinquency, crimes against women and children, and correction of offenders in its annual conferences, seminars, and workshops, and not on victims in the beginning years. The establishment of the new Department of Criminology at the University of Madras and the beginnings of victimological study. the subject of criminology, nurtured in the psychology department and housed in the Department of Psychology of the University of Madras for about a decade, got Philip within the next decade as it blossomed into a separate independent department of criminology in the University of Madras in April 1983. And I assumed office as the founding head of the Department of Criminology with 2 colleagues. During those days, when criminology itself was its beginnings in India, hardly any attention was paid to the victims of crime and their problems faced during and after their victimization and during the investigation, prosecution and disposal of the criminal cases by the criminal court. During that period, when the victimology was not a subject for academic study, research, or any intensive discussions in Indian universities, the newly established Department of Criminology of the University of Madras organized for the first time in India a 3-day regional seminar on victimology, exclusively focusing on access to justice for victims, the problems faced by the crime victims, and about the need for victim restitution, compensation, and assistance, with many colleagues and scholars from different universities and from criminal justice departments contributing and enriching the discussions at my initiative and leadership. The important papers presented in this major seminar on victimology resulted in a publication in the name of Readings in Victimology. During the same period, some sporadic victimological researches conducted in Sagar University in Madhya Pradesh in northern India also resulted in some publications on victims. And one of the major contributors was Professor Dr. Singh, D.R. Singh. The establishment of the Indian Society of Victimology. When I participated in the 6th World Society of Victimology International Symposium at Jerusalem in 1988, the idea for establishing a National Society of Victimology to advocate the cause of victims in India came to my mind. But implementing the idea was postponed as the Department of Criminology at the University of Madras was just 3 years old, and our priorities were to strengthen the academic programs, bring in international collaborations, and to meet the challenges of getting adequate infrastructure for the Department of Criminology, such as classrooms, faculty rooms, working space for research scholars, and for the project staff. Later, when I participated in the 7th WSV International Symposium on Victimology at Rio de Janeiro in Brazil in 1991, the need for establishing an organization for the study of victims and to raise the voice of victims in India was felt more intensively. In the year 1991, the World Society of Victimology, at its executive meeting held at Rio, unanimously resolved to co-opt me as a member of the executive committee of WSV for a 3-year term, 1991-94, in accordance with their policy to co-opt 3 members from developing countries, as the discipline of victimology was either unknown or at a rudimentary level in many developing countries like Africa, Latin America, and Asia. That way, among Asian countries, India being a huge democracy and a developing nation, got the opportunity for representation in the executive committee of WSV with only 15 members. My induction in the EC of WSV had given me more opportunity to develop contacts with the senior members of World Society of Victimology about establishing the Indian Society of Victimology, the pioneering organization of the study of victims in India. I must acknowledge the support given by then Secretary General of World Society of Victimology and my good friend for 3 decades, Professor Dr. Kirchhoff, to my idea of starting a forum for victims in India without any further delay. After my return from Rio in August 1991, I took a series of efforts to have discussions with my academic colleagues and some friends from police, such as senior police officers like R.K. Raghavan, who subsequently became the director of CBI, and Mr. L.N. Venkatesan, who retired as the Director General of Police of Tamil Nadu, who were senior Deputy Inspectors General of Police at that time. All of them fully supported my idea and promised to extend their full cooperation in establishing an organization for victims in India. In early 1992, a meeting was convened in the Department of Criminology, which was attended by many academics, lawyers, police officers, correctional officers, and research scholars. And this meeting, after long deliberations, felt unanimously that there was a need to establish an organization for victimology, to have a forum, to raise the voice of victims in India, and decided to name it as Indian Society of Victimology. This meeting framed the bylaws of the society and appointed the first office bearers of ISV, with me as its founder president and Dr. Tilagraj as its secretary, and 5 regional vice presidents, including Dr. R.K. Raghavan and Mr. L.N. Venkatesan. The bylaws of the society envisaged organization of a biennial conference of victimology once in 2 years as its major activity for exchange of ideas and sharing of research findings in victimology, besides organizing special lectures, seminars, and workshops on victimological issues on themes of current importance. After a few months in a grand gathering, the Indian Society of Victimology was formally inaugurated by the octogenarian jurist and former judge of the Supreme Court of India, Justice V.R. Krishnaiyer, at the University Centenary Buildings of the University of Madras, Chennai, on 14th August 1992. In the first couple of years, the ISV organized some seminars of local relevance with a huge participation of students and officials from the criminal justice system. The first biennial conference of the Indian Society of Victimology was organized for 3 days in August 1994 at Chennai. The former Minister of Education and the government of Tamil Nadu and the former Union Minister of Food and Agriculture, Mr. C. Subramaniam, inaugurated the conference and delivered the inaugural address, and Justice Ranganath Misra, the then chairperson of the National Human Rights Commission of India, delivered the keynote address. There were plenary sessions and many presentations of scientific papers on all the 3 days, and on the third day, Justice V.R. Krishnaiyer was the chief guest who delivered the valedictory address. Contributions of the Department of Criminology, University of Madras, to promote victimological research. Since late 1980s and throughout 1990s, the Department of Criminology of the University of Madras encouraged many research scholars and master's students to undertake research on victimological issues, either for their doctoral research or for their individual research and publications or for their master's dissertations. Simultaneously, other scholars who studied victims from other institutions and universities also made significant contributions to promote victimological research. Particularly, I would like to mention the significant contribution of Professor G.S. Bajpai, who has done a lot of publications and a lot of researches on the field of victimology. Major contributions of Indian Society of Victimology for the victimological movement in India. The Indian Society of Victimology, with the help and support of Professor Madhava Menon and his students, produced a draft bill on victim assistance. The second biennial conference of the Indian Society of Victimology in 1994 took this victim assistance draft bill as the major theme of the conference for elaborate discussions among the participants, class by class, to finalize the draft bill in Bangalore in 1995. After the draft bill on victim assistance with certain modifications was made ready in the second biennial conference of the Indian Society of Victimology, ISV, with the support of National Human Rights Commission, particularly Justice V.S. Malimath, then member of the NHRC, with a passion for justice for victims, convened a high-level workshop for 1 day, inviting about 20 selected senior experts who were from higher judiciary, police, prosecution, and academics, which was chaired from morning to evening continuously by Justice V.R. Krishnaiyer at Chennai. And this workshop reviewed all the provisions of the draft bill and made suitable modifications and amendments, and finalized the Victims' Criminal Injuries Right to Assistance Bill 1996. The draft bill on victim assistance was forwarded by Justice Krishnaiyer himself to the Ministry of Home Affairs and Ministry of Law and Justice, Government of India, for their consideration to make it a national level legislation. Justice Krishnaiyer also wrote to the then Home Minister of India, Inderjit Gupta, in the year 1996, to take steps to pass this law in the Parliament and make it applicable to all the states in India to benefit the victims of the whole nation. The UN Commission on Crime Prevention and Criminal Justice also hailed the efforts of Indian Society of Victimology to make a draft bill on victim assistance, and recommended to the Government of India to consider to bring victim legislation treating the draft bill of the Indian Society of Victimology as a model. Many jurists like Justice Krishnaiyer, former Chief Justice of India, Justice M. Venkatachalaya, and former Chief Justice of Kerala High Court, and the member of the National Human Rights Commission of India, Justice Maliman, academic scholar like Professor Madhav Menon, all emphasized the need for a victim legislation to make victim compensation mandatory. At that time, you didn't have the victim compensation as you have today after the 2008 criminal law amendment. As a matter of fact, Justice Venkatachalaya, in his report of the National Commission to review the working of the Constitution, specifically mentioned that lack of monetary resources is not a valid argument at all to provide victim compensation, and this cannot be acceptable. Even in the report of the Committee on Criminal Law Reforms, headed by Justice Malimat, referred to the efforts of the Indian Society of Victimology to bring in a comprehensive victim legislation providing victim compensation in India, and endorsed the same. Now, for the first time in India, the Victim Assistance Fund was created by the government of Tamil Nadu with the efforts of the Indian Society of Victimology. Meanwhile, due to the consistent efforts of the Indian Society of Victimology, the government of Tamil Nadu had established a Victim Assistance Fund since 1995, through which 3 specific categories of victims of violent crimes, murder, namely murder, rape, and grievous hurt, were made eligible to get compensation of rupees 10,000, 5,000, and 5,000 respectively, recognizing the need of the victim, though this is a very, very, very small amount, which is a token. But it's a big victory because for the first time there was a recognition of the suffering of the victim. The government of Tamil Nadu allotted 10 million rupees, 1 crore rupees in the year 1995 by the announcement of this scheme by then Chief Minister Jayalalitha in the Legislative Assembly. And that is being reviewed year after year and carried out some amendments in the particular government order in the year 1997. In May 1999, the government of Tamil Nadu extended the compensation to 3 more categories of victims, namely women victims of kidnapping and abduction with rupees 5,000, victims of attempted murder in dowry harassment with rupees 5,000 if the victim dies, children of victims who commit suicide with rupees 10,000, and women who are permanently disabled in a dowry harassment with rupees 5,000. Then Criminal Law Amendment Act 2008 and victim compensation provisions in India. The leaping changes occurred after 2005. Under the Code of Criminal Procedure 1973, by introducing an amendment and inserting a section 357A, victim compensation scheme has been elaborated as follows, which most of the law students are aware. Every state government, in coordination with central government, shall prepare a scheme under this amendment for providing a fund for victims. Whenever a court recommends for compensation, the District Legal Services Authority or the State Legal Services Authority shall decide the amount of compensation to be awarded under the scheme. If the trial court is satisfied that the compensation awarded is inadequate, or where the cases end in acquittal or discharge, and the victim has to be treated, it may make a recommendation for compensation. Where the offender is not traced or identified, but the victim has been identified, and no trial takes place, the victim or her dependents may make an application to the state or district legal service authority for an award of compensation. On receipt of such recommendations, the state or the district legal service authority shall award adequate compensation by completing an inquiry and make a decision within 2 months of time. The state or district legal service authority may order for immediate first aid, medical benefits, or any other interim relief to be made available free of cost based on the certification of the police officer or a magistrate. Actually, this kind of assistance has been pleaded by Professor Sani for a long time after the Center of Victimology and Psychological Studies has been established. In fact, his vision was, all of you know, to have such victim protection and victim assistance throughout the country, and as a token, he has just started in the state of Haryana. The state or district legal service authority may order for immediate first aid, medical benefits, or any other interim relief to be made available free of cost based on the certification of the police officer or a magistrate. Under section 372, a provision has been inserted giving the victim a right to make an appeal against any order passed by the court, acquitting the accused or convicting for a lesser offense, or imposing inadequate compensation. And many of you subsequently, you know, the focus on victims and the seriousness of victimization and the need for the government to do something urgently was made by the revelations after the Nirbhaya attack, Nirbhaya sexual victimization. The victimological movement in India was promoted by many events at different points of time. One of the shocking events which stirred the conscience of the people of India was the horrible victimization of brutal rape of a young medical student, Nirbhaya, in a moving bus in Delhi on December 16, 2012. The news of gang rape of Nirbhaya sparked unprecedented anger, shame, disgust, and horror across the world, including Delhi and many other cities and towns in India. The interesting feature of this movement is assembly of people voluntarily in public places, even without a leader to direct the movement, inciting emotions of anger and dissent at the state and central governments and the police forces. Thousands of civilian protesters resorted to candlelight vigils and peaceful demonstrations in Delhi, culminating in certain amendments in criminal laws and setting up of a fast-track court to prosecute the perpetrators. The unprecedented outburst in Nirbhaya's victimization opened up a hitherto non-existent space for victims and persons close to them to speak out against sexual violence. After these public protests, there was a significant increase in the reporting of rape cases, giving courage to many survivors of sexual assault to report it, unlike before. The significance of the movement goes beyond the incident itself, as it also led to discussions surrounding similar serious crime incidents that have happened before and after. Activists and journalists addressed the issues and that were mostly neglected by mainstream narratives, such as the caste-based sexual violence in rural areas and marital rape. Twitter and Facebook exchanges on sexual politics and violence also gravitated towards the unidentified Nirbhayas. The word survivor started being used in public discourse instead of the term victim, since activists stress the importance of rape being understood as another form of violence, as opposed to its construction as the worst form of violence that can be inflicted upon someone. It was also acknowledged that men and transgender victims are also raped, and sexual violence is not only a women's issue. The impact of movement was felt across South Asian countries like Pakistan, Bangladesh, Sri Lanka, and Nepal, where marches and demonstrations against sexual violence were held, and the movement was hailed as the rebirth of the fight for gender equality in South Asia. On December 23, 2012, a three-member committee headed by Justice J.S. Verma, former Chief Justice of the Supreme Court of India, was constituted to recommend amendments to the criminal law so as to provide for quicker trial and enhanced punishment for criminals accused of committing sexual assault against women. The committee in its report submitted on January 23, 2013 made recommendations on laws related to rape, sexual harassment, trafficking, child sexual abuse, medical examination of victims, police, besides certain other items. Despite the allocation of 200 crores of rupees towards the Central Victim Compensation Fund, which was named as Nirbhaya Fund, to be utilized for the victim compensation, media reported victim rehabilitation and victim awareness programs by the government of India. Only 10% of the total corpus has been released under the scheme to assist rape victims. The release of a mere 10% of funds spoke volumes of the status of compensation given to the victims of sexual assault in the country. The sad story is that most of the survivors of sexual assault or acid attacks were not aware that they were entitled to compensation by the state. According to an NGO working in this field, the law enforcement agencies of none of the states in India have taken much effort to spread awareness about central victim compensation. In fact, when we studied years ago in Chennai about the implementation of Victim Assistance Fund, which was created by the government of Tamil Nadu, we found, surprisingly, we thought we were pleading that the money was small amount, but we found in our study that more than 50% of the money was unutilized. That means people were not, the police had not informed, or the criminal justice our agencies have not communicated this availability of victim assistance fund. So that is the case with, yeah. So now let me conclude that you have heard this is a long struggle. Victim justice has been a struggle throughout the world. And for a country like India, with the entire focus was on criminal, and the criminal justice system was more bothered about the punishment of the offender. And the judges, the entire judiciary were not oriented with the victim justice. Now, the victim justice took a long time. Now, there has been a lot of awareness, but still a lot more to be done, particularly the need for sensitization of the judiciary and the police officers. Now, at the higher level, in the National Police Academy and National Judicial Academy, the topics relating to victim justice and the need to sensitize the judiciary and police officers about the type of treatment the victim deserves are discussed and debated, and they are informed. But we need a lot more in this area, and the centers like Center for Victimology and Victim Assistance, run under the leadership of Professor Sani, have to take up in a much more. We, about 30 years ago, we have done a little, but much more to be done, which are to be done by the current young people, young research scholars in India. But we are proud that we are making progress, and we will continue to make progress and get full justice to victims of crime and abuse of power. Thank you very much for your patience.
Thank you, Professor Chokalingam. In just last 32 years, you have done a remarkable job. I would say it's a remarkable journey being led by you. And we assure you that through the Jindal Institute of Behavioral Sciences and Center for Victimology and Psychological Studies, we are right now have 6 PhD students who are working on victimology. And we want that these findings and research should go to the government of India, and it should become a part of the victim assistance programs. And there are quite a lot of students over here that we have a PhD program, and we pay 25,000 rupees per month as a stipend, free stay, free food, and contingency. So those who are interested, they can apply in the Center of Victimology as well. Well, we are running half an hour late, 25 minutes late. And my only request is that if we can avoid question and answer sessions, Professor Chokalingam is available during lunch, during cultural program, during evening tea and dinner. So you can ask as many questions as you want. And because the next session, with your permission, if we can have in 45 minutes, instead of 1 hour, because question answer if we can, because we would like to finish today positively by 6 o'clock. We have arranged a very good cultural program because many foreigners are here. So school students have been invited to, and our own students are going to give presentation. So my request is that if we can restrict ourselves to the timings so that we can have all other activities well in time. Thank you very much. Yes.